Mr. Lynn?
Good morning.
Thanks.
May it please the Court, Paul Lynn for the Commonwealth. There are two crucial points that I want to make from the start this morning. And the first is that both of the judges who actually saw and heard Mr. Sheketoff, the defense attorney in this case, found him to be effective. First, the trial judge, Judge Volterra, found that Mr. Sheketoff's representation of the defendant at trial was not only adequate but exemplary. And then the motion judge, Judge Laureate, who heard Mr. Sheketoff testify at the hearing, also found Mr. Sheketoff to be effective. On appeal, both of these judges' decisions are entitled to substantial deference by this court. The trial judge's finding, of course, because he saw counsel's representation firsthand, and the motion judge's findings because he was in the best position to evaluate the weight and credibility of Mr. Sheketoff's testimony. The burden is on the defendant to show that these findings were clearly erroneous or that the judges otherwise abused their discretion. And as I will discuss further in a moment, the defendant has not met that burden.
Mr. Lynn, could you just help me on, there was a piece, and I can't find it immediately, in the appeals court memorandum that talked about Mr. Sheketoff's testimony, as I understood it, that he couldn't imagine why he wouldn't use the affidavit while, if the client was on the stand.
That's correct.
Now, but by the time the hearing on the motion for a new trial was taking place, I mean, everybody knew that the witness had taken the Fifth Amendment and had been declared unavailable.
Absolutely correct.
So I haven't had a chance to look at the transcript of the hearing. So how did that come about? Because the use of the affidavit could only have arisen in the context of the witness being unavailable.
It could have been used in either case, regardless of whether or not the witness was unavailable.
The witness was unavailable.
The witness was, in fact, unavailable at trial.
So by the time you get to the motion for a new hearing, you know that.
Yes, absolutely. And that's a crucial point in this case. What Mr. Sheketoff testified to, and you repeated this 3 times, was a fact that simply didn't exist in this case.
But why was he testifying about that?
I think he was trying to rationalize it in hindsight.
Well, did anyone cross-examine him then? We're not talking about if the witness were on the stand, but if the testimony were read in.
I can't say if that specific question was asked, but the questions all pertained to what actually happened at the trial. These questions, I can tell you, were not responsive to the questions that the prosecutor, Mr. Pappas, asked him at the hearing.
They were not responsive?
They were not responsive. They were volunteered. Okay. And this is not simply a technical distinction. If you look at the trial record, the fact that Mr. Kimbrough did not take the stand was a point that was emphasized at length by both Mr. Sheketoff and counsel for the co-defendant, Mr. Hughes, who was Stephen Hrones. Mr. Hrones argued that the jury had been deprived of an opportunity to evaluate Mr. Kimbrough's demeanor and credibility on the stand, and he said, you know, it's very hard for us, we're in a bad position, because it's, and this is almost a quote, it's very hard for the defense to impeach a piece of paper. And Mr. Sheketoff picked up on that theme. First of all, he argued that the jury should ignore any insinuations that have been made about why Mr. Kimbrough was absent, that they should not speculate on that subject at all, and again, that the defense had been put at a disadvantage because they couldn't impeach a piece of paper. In response to that, the prosecutor didn't even mention Kimbrough's absence in his closing argument. The closest he came was he said, this case isn't about a transcript, referring to the transcript of Mr. Kimbrough's testimony from the first trial. This case isn't about a transcript, it's about an armed robbery. So what the defense attorneys managed to do in this case is take the absence of Mr. Kimbrough and turn it into an issue that was entirely favorable to the defense. And so in that context...
Explain that to me, because, I mean, so Kimbrough is absent.
Correct.
As I understand it, Mr. Sheketoff in his opening argument told the jury that he would... you know, I forget what the words were, but he would have a witness, you know, who would contradict some of the Commonwealth's evidence. The witness disappears. Why does that turn out to be favorable to the defendant.
I don't believe he was referring to Mr. Kimbrough. I will check that. But
Okay.
as it turns out, both of the attorneys make this an issue of, look, he's not here. You should hold that against the Commonwealth, not against us. And the prosecutor doesn't even respond to that argument in his closing argument. And if this affidavit had been introduced, if Mr. Shektoff or Mr. Hrones had introduced this affidavit, it would have opened up the issue entirely, and the Commonwealth could have explored the issue of the alleged duress under which Mr. Kimbrough signed this affidavit.
Is that absolutely clear?
No, it's not absolutely clear, but it certainly was.
Well,
I was confused by that. Can you explain exactly what is shown on the record about this Miller Thomas? He's the one who then spoke to Kimbrough.
Absolutely.
At boot camp.
The record is slightly sketchy because the issue was completely taken off the table. But at sidebar, the judge explained what counsel had told him on the record. The judge explained on the record what counsel had told to him. And that was that Miller Thomas had gone down, Detective Miller Thomas, had gone down to the prison after learning of this affidavit, had interviewed the defendant, had interviewed Mr. Kimbrough, and Mr. Kimbrough had said that he had signed this affidavit under duress. Now, admittedly, there's some question as to whether the Commonwealth could have got that statement in, because it would have been hearsay. We would have had to have argued that the defense was really trying to bring in this affidavit for the truth of the matter. And
I understand that. So what's the base?
The base is what we certainly could have brought in, and what the prosecutor could have argued in closing argument, and all of this is from the record, is that Mr. Kimbrough's demeanor changed markedly from before and after he signed the affidavit. He was a cooperating witness before. After he signed the affidavit, Miller Thomas described him as terrified. He was scared.
And he signed the affidavit while in prison.
While in prison. The second point is that the person who witnessed the affidavit, Michael Holloway, was an acquaintance of the defendant and, in fact, provided an affidavit for Mr. Hudson himself prior to the second trial. There were also problems with the affidavit itself. By all accounts, Mr. Kimbrough was the first witness to implicate the defendant in this crime, and yet he claims in his affidavit that the police told him to implicate the defendant, even though the defendant wasn't even a suspect at the time.
Mr. Wynn, the duress was allegedly that Mr. Kimbrough was visited by several people in his cell.
That's correct.
I'm sorry.
Did they do more than visit? Do we know what was said?
We don't know. We have all we would have that from, of course, is Mr. Kimbrough himself, and he took the Fifth Amendment, and there's not a great deal of detail in the trial record about exactly what happened. But there certainly was enough to draw the inference, and for the prosecutor to argue to the jury that this affidavit had been obtained under duress.
This strikes me as the classic tactical decision that a lawyer has to make in the middle of a criminal trial where there's lots of different ways one can approach this.
That is exactly the Commonwealth's point. There's no way to look at this decision under the circumstances as manifestly unreasonable. And the appeals court actually, in its first decision, acknowledged this by ruling that if Mr. Shektoff had, in fact, been concerned about the potential for rebuttal evidence, that would have been a reasonable strategic decision. In their second opinion, they said, well, no, any reason he could have come up with was manifestly unreasonable, but that contradicts their first decision.
Let me ask you this question, because
Go ahead.
Manifestly unreasonable is sort of an objective standard looking at the circumstances.
Correct.
So, it strikes me, let's assume that the lawyer came in and said, I don't remember, I can't think of any reason why I would have done that intentionally. Does that matter? Can the court still find that it was not manifestly unreasonable because in the circumstances there were lots of reasons that might have justified this?
That's a very good question, Your Honor, and the answer is the law is not 100% clear. The law seems to say that if the defense attorney testifies that he had no strategic reason, and the judge credits that testimony, then the only question is whether the omitted evidence deprived the defendant, or the omission of the evidence deprived the defendant of an otherwise substantial ground of defense. That creates an odd situation because it means that a defendant on appeals has a better chance if he had a bad attorney, he was simply negligent, as opposed to a good attorney who made a strategic decision.
Again, it strikes me as quite odd, because manifestly unreasonable, as I say, seems to be an objective standard that you apply to the situation. As a reasonable attorney would apply, reasonable attorney within the parameters of what we expect of attorneys might decide.
But that actually brings me back to the second point I was going to make, and that is that the burden is entirely on the defendant to prove that counsel was ineffective. Now, that was made clear by this court in Commonwealth versus Comita, which is cited in the Commonwealth's brief. Now, the defendant has suggested that Comita applies only to the second prong of Safarian, but at page 90 of that decision, this court makes it clear that the defendant bears the burden of proving both prongs of the Safarian standard, even though it focused on the second prong in that case.
Mr. Len, let me just go back. You know, I've now found the place in the appeals court memorandum, because I remember you made this point in the brief. What difference does it make? You've got Sheketov saying he couldn't conceive of having the defendant on the witness stand and not says the defendant and not going after him with this affidavit, no matter what the Commonwealth is going to come back and say.
Absolutely.
Having the defendant.
I think that was either a misstatement or a misprint in the transcript. He means Mr. Kimbrough. So
assuming that Mr. Kimbrough had not taken the Fifth Amendment.
Correct.
He's now on the witness stand.
Correct.
And now, what he says that he's the worst. I mean, I'm really trying to understand why, if he's not there, it opens up. I mean, I literally didn't understand. He's either there saying, I was wrong, right?
Well, that's not clear. Again,
I mean, I'm trying to understand. I haven't read the transcript, but I don't understand what the appeals court is saying. Maybe I'll ask Mr. Schubert, but I don't understand what Mr. Sheketov was saying, assuming that it's a mistake.
Well, what Mr. Sheketov was saying, and he said it 3 times, and at least one of those times he referred to Mr. Kimbrough. What he was saying is that if Mr. Kimbrough had taken the stand and said, presumably, you know, that's the guy who did it. Now, as it's been pointed out, it's unclear what he would have said.
Okay, but let's assume that he did that.
Yes. Under those circumstances, with the witness on the stand testifying live, Mr. Sheketov said, I can't imagine that I wouldn't have put in that affidavit to show that he had recanted his testimony, come what may.
What about
but then why doesn't that open up? That would open up even much more likely, it seemed to me, that the Commonwealth then would have been able to get in the officer's testimony.
Oh, absolutely. There's no question about that.
So I don't understand the point about, well, it makes a difference whether he was or wasn't. In other words, if Sheketov is saying, I can't understand, because I don't care what the Commonwealth is going to throw at me, I've got recanted testimony. Now, if the witness is unavailable, right, and there's a less of a chance that the Commonwealth will be able to persuade the judge, it seemed to me.
The issue is that a strategic decision is a balancing test, the benefits versus the drawbacks. And I think what Mr. Sheketov was saying, and certainly it wasn't clearly erroneous for the judge to find this, is that if Mr. Kimbrough had taken the stand, the power of his testimony would have been such that I would have had to have brought in this recantation, even though it would have opened the door to this rebuttal testimony. But since he wasn't there, the judge was entirely within his discretion to say that the defendant has not met his burden. It's important to realize exactly what Judge Laureate found. His primary finding was that Mr. Sheketov simply does not remember 7 years after the trial, why he didn't put in this affidavit.
It seems to me that is much more important than the appeals court gave it credit.
Absolutely.
To me, that's almost the beginning and the end of it. I mean, Mr. Sheketov has done any busy criminal defense lawyer, tries so many cases a year to ask somebody why they did something 7 years before in one particular case at one particular moment.
Right.
It's impossible. When he says he doesn't remember, I'm sure that's truthful. And where the judge found that he didn't remember, it would seem to me that he's saying that looking at the cold record and thinking this and thinking that, It's inconceivable, I wouldn't have done it. But he says over and over, I didn't remember, and the judge found he didn't remember.
That's absolutely the Commonwealth's position. I want to make two more points very quickly. The first is Mr. Schubert has suggested that this was manufacturing a strategic reason. It isn't manufacturing a strategic reason. The burden is on the burden is not on counsel to explain his decision. The burden is on the defendant to show that counsel didn't have a reasonable explanation. And where the judge found that Mr. Sheketoff couldn't remember why he had done this, but there was a reasonable strategic reason out there that he might have had, it was well within the judge's discretion to find that the defendant had not met his burden of proving that this was not a reasonable strategic decision. I see my time is up. Are there further questions?
Thank you, Mr. Lynn.
Thank you very much, Your Honor.
May it please the Court, I'm Attorney Greg Schubert, representing the appellee, Mac Hudson. If Your Honors, please, if you take a look at my brother's first point to you, which is that the Commonwealth is entitled to the findings of Judge Volterro and to the motion judge relative to these proceedings. I suggest to you that Judge Volterro's findings are like a cheerleader at a high school pep rally, and the references to the performance of Mr. Sheketoff go beyond anything that is viable, and I have yet, in my 32 years of doing murder cases, have ever seen a trial judge write anything but glowing reports of the performance of counsel during a first-degree murder trial. Secondly, I suggest to you that the record adequately proves one thing to you about what the motion judge found, and that is that after the judge had made his findings of facts, conclusions of law, and issued them, the appeals court dismissed my appeal. I then sent them a request to have them look at the actual transcript record of what was testified to, and it took us an awfully long time to get those results. But when they did, and when they analyzed that, and they saw that, and I suggest that this court can do the same thing and arrive at an independent conclusion, and that your conclusion will be absolutely the same.
Which is, our conclusion about what was testified to will be what?
That, in fact, that there is a total misrepresentation by the motion judge as to what was testified to.
So the correct finding is what?
The correct finding is
as to the attorney's conduct on this point.
That there was ineffective assistance.
Why?
No, why?
Why? Because of the fact that he failed, number one, to put in the recantation.
Perfectly reasonable choice. Isn't that a reasonable choice?
It is not, in my opinion, sir.
How do you explain the duress?
Sir, number one, you would have to assume that Mr. Kimbrough was going to take the stand, and this is a total leap of faith, based on allegedly one police officer's alleged conversation at the jail, that Mr. Kimbrough wasn't going to say to the jury, yes, I lied at the first trial.
But he wasn't going to take the stand. All you had was an affidavit.
Well, he would have testified if he hadn't been declared unavailable.
But he was. We have to deal with what happened.
What we have to suggest is that if you read the transcript of what I believe Attorney Sheketoff testified to, the real reason that he sort of lost it and didn't put in the recantation was because
he never said he lost it. I mean, I don't know. It's not in any of what I
Your Honor, in my opinion at least, he suggests that he was so angry at the decision, okay, to make the witness unavailable and allow the first trial's testimony to be read into the record and be left with that to deal with during the second trial, that his performance was less than stellar. That's the position of the defendant in this particular case. And I point out, it was further heightened, this difficulty, by the fact that Mr. Sheketoff violated the CPCS standards of arguing the direct appeal. He couldn't even raise his own ineffectiveness or bring these issues to the attention of this court.
You're making a very serious charge there.
Well, it's well known that in the eastern part of the state, Mr. Davis said Mr. Sheketoff on numerous occasions handled direct appeals when the Committee for Public Counsel Services has had in its guidelines since the beginning of the murder list assignment, of which I can't even name you an attorney in the western part of the state that has ever done a trial and then the direct appeal of that case unless it was a private case. Well, on appointment cases, that is an absolute mandate that should never have happened.
Well, let's look at it this way. The judge, you've got an attorney who doesn't remember precisely why he did what he did here. And it's not just the failure to impeach with the affidavit. It's the failure to call these other witnesses who were in jail, who also would have said, Kimbrough, the witness, told me that he lied.
Correct.
And it strikes me that that series of decisions is within a range of decisions that an attorney might be made, depending on the defense. He had cross-examined Kimbrough extensively at the first trial, and I understand did a very fine job of that, so Kimbrough was significantly damaged. There were a whole bunch of additional criminal convictions that were admitted against Kimbrough, even in his absence. So you have an absent witness who was very strongly cross-examined first time around, who is very vulnerable. The question is whether you want to bring into this case a whole new picture of duress, possible collusion, and call witnesses who themselves have extensive criminal records, when the theory of the case is the one witness against my client is a guy with a long criminal record and is looking for a favor. You shouldn't believe him. Are you then going to call a whole bunch of fellow prison inmates to testify about who said what to whom in prison, with their long records as part of your defense? I mean, it strikes me that this is a tough decision, but one within the range of reasonableness, and why should we upset that?
I can really tell you, sir, that every day in the Commonwealth of Massachusetts in murder trials, the government puts forth the lousiest people on earth with criminal records that are absolutely horrible and expects people to believe their testimony.
I understand.
Why would it be
and that's a big vulnerability.
Why would it be different for the defense?
Well, where are they supposed to get their witnesses? In church? They're not. The people that the defendants are friends with are the people that the Commonwealth uses as witnesses.
And precisely the point I'm sure that Mr. Shekikoff would have made had he been forced to make that point by putting on these particular witnesses. That's my answer to that. The flip side of the coin is the exact same.
That's one way to try the case, though. That's one way to try the case. The other way to try the case is the only witnesses against my client have long criminal records. They have a lot to lose. They are in bed with the government, and to do that cleanly without then calling all of your other friends from jail to talk about their long criminal records on your behalf and muddy the waters on where the angels lie or where the truth might lie in this case. I mean, that's a very hard but a strategic decision within, I think, a range of reasonableness.
Mr. Schubert, what was the most powerful testimony against this defendant?
I'm sorry.
What was the most powerful testimony against this defendant at the second trial?
Well, I actually think it's the read into the record testimony of Kimbrough.
Well, there were other witnesses that
there were, but
he's the one that did other witnesses put this defendant as the shooter?
Well, it brings me to an issue that it's somewhat hesitant to raise, but if you believe what the government really posits in this case, that Hudson walks back, shoots the guy in the face, one sort of has to ask yourself whether or not, if the jury believed that, why wasn't there a return of murder in the first degree?
Well, that wasn't my question, because again, I haven't looked at the trial testimony. But what was the most, is it your position that the most powerful testimony was the testimony that was read in of Mr. Kimbrough at the second trial?
Yes.
There were other eyewitnesses, however, that picked your client out.
Mr. Shekitoff did object. What instruction did Mr. Shekitoff or Mr. Sloans ask the judge to give to the jury as to why Mr. Kimbrough's testimony was going to be read in?
My memory does not serve me that there was any request for an instruction relative to that.
So, as I understand it, there was an objection to the judge simply saying he's unavailable, correct?
That is correct, as I understand it. And the last point that I just make is that relative to the alibi witness, the government argues that what substance would the alibi witness have had relative to this? And the government's argument has to fall on false ears here because, I mean, there isn't a criminal attorney around that's doing first-degree murder work on the capital crimes list that doesn't know that you're going to suffer a really serious sanction if you tell the government on the day that you're going to put a witness on that you've already just decided that you've found an alibi witness.
What about the rule that requires notice of alibi witnesses?
Oh, absolutely, and it's part of the ineffectiveness claim, undoubtedly. Mr. Shekikoff knew that he can't play games.
I was a little surprised by the motion judge's comment on that. You know, it was essentially saying that his decision was tactical on purpose. He did not wish to appraise the Commonwealth in advance of a witness whose alibi testimony was shaky at best. I mean...
Judge, I reiterate what the primary basis of my argument is. The motion judge's findings and actual opinion is valueless because it does not represent what was testified to, and it is an extortion of the truth. I believe that that's what the appeals court found, and that's why they reversed their decision dismissing my appeal. And I think that that was a fair evaluation of the performance of the motion judge.
Mr. Schubert, do you happen to know what date the hearing on the motion for a new trial was?
I believe it was sometime in May of 2004.
So the judge's findings followed very promptly after the hearing?
It did.
Okay.
And I believe it took over 6 months to get a transcript.
Oh, that I understand, but the judge is writing his findings based on recent memory.
All I know is that I believe I made 4 actual trips to argue in front of the motion judge, and that the evidence was clear at that point in time, and when I read the initial findings, I felt compelled for the first time to file a motion for reconsideration. And to the best of the Committee for Public Counsel Services knowledge, this is the first time in a murder case that the appeals court has ever granted a motion for reconsideration and then reversed itself after reading the actual transcript. If there are no further questions,
Thank you, Mr. Schubert.